So I say that by way of opening. I have a word cloud here of things that sitting federal judges have said about the Department of Justice's presentations in this Trump II administration. To be clear, these are not allegations that are made about the Department of Justice by angry or frustrated opponents. These are findings made by federal judges. And I think every one of those words, if it had been spoken about my office when I was US Attorney, would have occasioned an office response. We would at minimum have had a meeting with the attorney and asked for an explanation. It could very well have resulted in a referral to OPR, Office of Professional Responsibility, within the Department of Justice, which, by the way, I'd need to see a proof of life from right now. And it could easily have meant like going over to the court to try to make amends and set things right, because the department's reputation with courts is its most important asset. What was the case in all your years in the so-called Sovereign District of New York with respect to that type of adverse finding about the competence and honesty of AUSAs?
You know, Senator, that's a really good point. You know, we talk about the Justice Department losing credibility and losing the trust of the public. And we don't talk enough about what happens when you lose the trust of the bench. We have a acting attorney general who has referred to the bench as declaring war on the activist judges. I can tell you this, in my years in running White Plains in particular, as well as downtown in Manhattan, if a judge had a problem with an assistant United States attorney, and it could be what now I would see as a very minor problem, I would immediately deal with it and speak to the assistant, figure out what happened, listen to the judge's complaints carefully. But if a judge made a finding that someone was less than candid or failed to comply with an order, that's really a big deal. And when a judge makes a finding like that, under traditional, as you know, from being a U.S. attorney, that's something that would be reported to Main Justice, and it would be something that would be carefully evaluated. If there's a Brady violation, carefully evaluated. What I think we see now is a broad lack of trust by the bench in the representations that are made by the government. There was a time when an assistant United States attorney walked into a courtroom and said, "I represent the government." That meant something. It meant something because the judges were confident that that assistant United States attorney was going to be candid, was going to be well prepared, and was going to be doing the right thing. And I think, sadly, what that collage reflects is a sentiment from many judges that's no longer the case.
For the record, that included Trump-appointed judges saying
Absolutely.
those things about lawyers. This is not just so-called activist judges. The department almost makes it worse when they receive criticism, and instead of responding to it honorably, they turn on and attack the judges. Well, you know, the judges tend to know each other. And when a judge who every other judge knows and knows perfectly well is no activist gets called an activist, that's just further damage to the department's credibility.
Credibility and ability to actually do the mission of the Justice Department, to carry out justice. When you don't have credibility with the court, or you lose credibility with the court, more broadly.
Say a word about the presumption of regularity. What is that phrase? What does it mean? What does it matter for the department?
Well, the presumption of regularity is something that the department has enjoyed, at least in my years in the department. The judges assume that you're acting in good faith and that nothing improper happened or untoward. You know, in the context of getting grand jury minutes or getting access to grand jury minutes, we've seen unprecedented number of judges ordering access to the grand jury minutes. That, as you know, that's something that the law is very, it's very, very good for the government on. You don't get access to grand jury minutes unless you can show there's a reason to go behind because there is a presumption of regularity. Well, that presumption more and more is no longer attaching.
Pay attention to the phrase the former prosecutor just defined, presumption of regularity. That's the default assumption every federal judge starts with when a government lawyer walks into a courtroom. Assume good faith. Assume the AUSA is being honest. Assume nothing improper is happening behind the scenes. That assumption is the engine of the federal system, and watch what Senator Whitehouse just laid out. Judges are no longer extending it. They're being forced to order up grand jury minutes on the regular. They're handing down findings against their own DOJ lawyers. And when the bench pushes back, the acting attorney general calls the judges activists, calls their rulings declarations of war. That's not a defense, that's an admission. Federal judges know each other. They know exactly which judges are activists and which ones aren't. Pick the wrong target, and you just proved the point you were trying to fight.
If you don't mind, one last episode that I'll walk you through. This was an episode not in the Southern District of New York, but here in the District for the District of Columbia by a political appointee directly supervised by Todd Blanche. And it was basically a cooked-up criminal investigation. First of all, it was a criminal investigation that was pursued without predication that there was a crime. Would that be unusual in a normal Department of Justice?
Well, certainly when it comes to the more complicated the case, the more sensitive the case, the more predication you should have before beginning an investigation.
But there should, at a minimum, be some
There should
predication.
be, even in the simplest of cases,
Yep.
there should be some predication.
And when the criminal chief of the career criminal chief of the office loses her job for being unwilling to pursue the no predication criminal investigation, that in a normal Department of Justice would be another warning sign, would it not?
It would be a red flashing light.
Yeah. And if no career member of the office would be willing to sign a pleading and the U.S. Attorney went forward alone with zero willingness to co-sign the pleading by any career person, another red flag?
Flashing lights.
Yeah, flashing lights. And if the...
Now listen to how the senator stacks the red flags. One at a time. Watch the rhythm. First red flag, the criminal investigation launched with no predication. No underlying crime to investigate. Second red flag, the career criminal chief who refused to play along lost her job. Third, no career lawyer in the office would co-sign the pleading. Fourth, the acting U.S. attorney filed it solo, with zero federal prosecution experience at the time. Fifth, the magistrate judge denied the petition. And sixth, after the denial, the department tried to shop the very same case to other U.S. attorneys' offices. They got rejected, so they went hunting for a friendlier judge. In the meantime, the client agency, the EPA, had its administrator on television preemptively accusing the targets of criminality before any charges existed. Every single rule the witness just spent his career enforcing. broken in sequence. And the man who orchestrated all of it. Solo filer, no experience, denied by the magistrate, is now the pardon attorney for the United States. Read that twice.
US Attorney went forward themselves with no career co-signer and had zero federal prosecution experience at the time. That would be more red flags, wouldn't it?
That would be a very, very serious problem.
Yeah, going into the magistrate's office, the rest of the courthouse would have heard about that by sundown. And the magistrate judge then denied that acting U.S. attorney's petition. That's a pretty damned rare occurrence because department lawyers bend over backwards to make sure that they don't put judges in the position of having to deny petitions by super preparing to make sure that there is no occasion for a judge to deny the warrant application.
Well said. And I just want to point out, in that scenario, kudos to those career public servants who refused to sign off on that.
And then after the magistrate denied the U.S. Attorney's solo petition, the department then tried to shop the very same case to other U.S. Attorney's offices. Was that a thing in a normal Department of Justice, to get shot down in one district and try to shop the same thing to other districts?
No, that would be extraordinary, and it would be totally improper and provide yet another reason for why the presumption of regularity is something that's in serious jeopardy.
And the last bit in this particular saga was that the client agency was the Environmental Protection Administration. And the EPA administrator was on talk shows and in the public arena accusing the subjects of the failed criminal inquiry of criminality. What were the restraints when an investigation or prosecution was going on in a normal Department of Justice about either the department or its agency client publicly disparaging the putative defendant?
So the Justice Department has very clear rules about what can be said and not said about people under investigation, or and Mr. Carr is probably an expert in this, but you certainly can't go out and disparage someone who you're investigating. Typically, you stick within the four corners of a charging document. When it comes to investigations, absent certain exceptions, you really should not be talking about a pending investigation.
Because it's wrong, because it's unfair.
Very unfair.
So the way this ended, the sort of punchline here is that the acting U.S. attorney who performed all these stunts is now our pardon attorney, Mr. Martin.